Office Procedures, Chapter 2, Trust Accounts. By definition, a trust account is an account with the exclusive purpose of holding money which belongs to others. The money is held in trust for another. This is why we refer to them as trust accounts. Real estate licensees often are required to handle funds belonging to their clients. In order to protect the client's money, Utah rules and statutes contain very specific provisions on how real estate licensees are to handle funds belonging to their clients. In the interest of protecting clients' funds, all real estate brokerages are required to have a trust account for handling of clients' funds. The rules set forth the following requirements for trust accounts. Trust accounts must be opened at a Utah bank, credit union, or other approved depository. The principal broker is personally responsible for all deposits in the trust account at all times. The trust account must be non-interest bearing unless certain requirements are met, which we will discuss later. The principal broker must notify the division of the location and account numbers of all trust accounts. Real estate trust accounts are to be used exclusively for Utah real estate transactions regulated by the division. For example, funds from the rental of vacation properties shall not be deposited in the trust account. As we discussed in licensing law, such transactions are not covered by the statute. Let's discuss when a licensee would be handling their client's funds. The most common situation occurs in conjunction with the purchase or sale of real estate. When a buyer makes an offer on real estate, the offer often includes earnest money. We'll discuss the purpose and details of earnest money deposits in another course. Oversimplifying, an earnest money deposit shows that the buyer is serious and provides for potential future damages in the case of default on the contract. Let's review the logistics of an earnest money deposit. We'll assume you're representing a potential buyer on a residential property. You show your buyer several properties and they decide to make an offer on a certain home. As you are writing up the offer, you ask how much the buyer would like to put down as earnest money deposit. This amount is included on the contract. Let's assume the buyer decides on an earnest money deposit of $1,000. If the earnest money is in the form of a check, the check is made payable to your brokerage. You are the agent representing the buyer. The standard contract requires you sign the purchase contract acknowledging the receipt of the earnest money check. Do not sign the acknowledgement unless you actually have the earnest money check. You then hold the check while you negotiate the offer. You present the offer to the seller's agent. The rules state any money received from clients must be deposited in the real estate trust account within 3 banking days of receipt of the funds, unless otherwise specified in a purchase contract. The standard purchase contract used in Utah states that the earnest money must be deposited into the real estate trust account within 4 calendar days of receipt of the deposit, which must be delivered within 4 calendar days of acceptance. Why do we care? You may be asking why depositing the earnest money within a certain amount of time is so important. You may also be asking about the consequences of missing the deposit deadline. Before we get into the details, we address one of the purposes of the earnest money deposit. When the seller accepts an offer from a buyer, the earnest money is important because it is the money the buyer is willing to put at risk in the event the buyer does not fulfill their obligations under the contract. For example, if the buyer decides not to close on the transaction the day before closing, the seller may be able to keep the earnest money deposit. If the buyer only puts $100 down as earnest money, the seller may not be willing to take their home off the market while the buyer is obtaining financing and making other preparations to close. The $100 may not show that the buyer is really serious about closing. If the buyer puts down earnest money of $10,000, the seller may be more likely to accept the offer. Please note that we are grossly oversimplifying earnest money deposits for illustrative purposes. The seller may be the defaulting party, in which case the earnest money also plays a role. As we mentioned previously, we cover these details in another course. The bottom line is that the seller relies on the earnest money stated in the offer when deciding whether or not to accept the offer from the buyer. Let's assume some hypothetical situations. A buyer gives you an earnest money check, which you give to your principal broker within 4 calendar days of receipt of the offer to be deposited. A few days after the check is deposited, your principal broker receives notification from their bank that the earnest money check has bounced or returned for non-sufficient funds. Your broker notifies you of the situation. You should immediately inform the seller's agent that the earnest money check has bounced. The seller may then decide whether or not to declare a breach of contract by the buyer. Since the check was deposited on time, neither you nor your principal broker are responsible for the bounced check.